On now to charging. Obviously, the next big stage. Everything we've talked about so far from the very beginning is all really related to charging, and a lot of these processes happen at the same time. Advocating for a client on charges starts from the very first time you speak to law enforcement. And most negotiations, I'm sorry, we have a question, so one moment. The question is, would you encourage a client to disclose all criminal activity when proffering in order to cast a wide net of immunity, or is the proffer very prescribed? So, really great question. You always want to advise your client to just answer the question that's asked. You get to a certain point, if they've answered the questions just as asked without trying to give more or give what they think the prosecutor wants to hear. And if they don't know how to answer the question as asked, then we ask to rephrase. But you don't want the client, certainly for the first session, disclosing criminal activity that wasn't asked about. But the client, they might say, I had a case that was illegal wildlife smuggling from Australia, a serious wildlife case, for as serious as they can be. They're very interesting. And my client was asked towards the end of the first proffer session, and we prepared for it, have you ever smuggled wildlife before in any fashion? That's, I think, going to your point, it's a really hard judgment call, and your fallback is always they already know the answer to the question, okay? Because if you don't cast this wide net, or if you don't answer the question because you're like, well, this is not even what this case is about, then, and they know that you've done it before, well, then your client is screwed and you've done a terrible job as your attorney. So basically, yes, any criminal activity that is asked about should definitely be provided and answered truthfully. As the attorney, we want the proffer sessions to be prescribed as much as possible. One of our goals, a practice a tip, is you want to have a conversation. I always try and have at least a video call, if not a sit down, before the proffer session to find out what exactly they're going to be asking my client about. Some prosecutors like it depending on the case or just the prosecutor's own way of investigating. Others do not. Others want to catch your client off guard so he doesn't have time, he or she have time to prepare his answers. But as the attorney, you want it to be as clearly defined as possible. Otherwise, you don't know what your client might say if you haven't been able to prepare for it. So that's why the preparation is so important as well. So yes, to answer your question, you want to answer everything they ask so you have that use immunity for whatever they ask. And I've had clients who have admitted and confessed truthfully to crimes that were not under investigation, and they did receive immunity for those because they were the only source of discovering it. So it's very important, but your client has to know that. It's not easy to have a client go in there and if he's accused of smuggling tigers to then just offer up, have you ever smuggled anything else? Well, why would I tell them that? I'm just going to get charged again. I always say, if you're not prepared to answer that, then we shouldn't do this because they might already have the answer. So hopefully that answers your question. So some of the fundamentals of charging, again, this process starts in the very beginning. Most negotiating, successful negotiating happens before the charges are brought. Your ability to affect a outcome of a case that you're trying to resolve in federal court is limited. It's very limited, and that's why it's very difficult practice, but very rewarding. It's not like state court. One of the main things you can negotiate, often the only thing you can negotiate, is what charge are we going to proceed under, and how do we get there? By proffering, by giving us leverage and cooperating, and then that's when the negotiation starts. Sometimes before, sometimes after, but it very often starts at the very beginning, because that's the benefit that you're getting by cooperating. If you are, is a reduction in charges or no charges at all. And prosecutors very often say, and it really is the truth, the best offer you're going to get is the one that we're able to negotiate before we have to go to a grand jury. And that's for several reasons, because if you negotiate the charges prior, and you can negotiate the charges prior to a grand jury, in the very beginning, you can say, we negotiate, my client will, in order to not go through the process, not make you go through a grand jury, save taxpayer dollars, pandemic, things like that. We will agree early on to agree to a charge, not necessarily what the plea will be, but we will sign a draft of a plea and commit to a one count of a wire fraud. Whereas if you went to a grand jury, they could come back with 25 counts of wire fraud. Or if there's 1,000 emails that are fraudulent sent to somebody if I'm in Florida, sent to Georgia, technically they could come with 1,000, but they don't do that. But very common in child pornography as well, is to say, we'll agree to not make you go through a grand jury if you don't charge every image or every video. So definitely starts very early. And then the one caveat to that is you can also get better deals if you find some sort of major evidentiary hole and you have a great motion to suppress, or the trial starts falling apart. That's common in state court, where we can beat the prosecutors up with motions and smoke them in trial. Federal process is different. It can still happen, but it's just simply not as likely because of the nature of the investigation that they do and the resources that the federal government has compared to whoever your local law enforcement is or state law enforcement. So in the slides, I talk here, this is again the DOJ manual, which is great, that the reasons, the fundamentals of why a prosecutor should bring a charge. It's good to know, especially number 3 is, this says they should bring a charge sufficient to obtain, if the evidence is sufficient to obtain a conviction, unless prosecution would serve no substantial federal interest. That really means that it's a state matter. The person is subject to effective prosecution in another jurisdiction, does happen, and there exists an adequate non-criminal alternative to prosecution. They don't really go on that, especially since the pandemic, when there was no grand juries and the Department of Justice gets paid based on grand juries and convictions. So they are really taking everything they can now. Non-criminal alternatives are much more difficult than they were before the pandemic, for how much money was lost by the federal government during the pandemic. DOJ Justice Manual is great because it's in their own terms and can be used against you. It lays out the standards for them to follow. For example, DOJ 9-2730, and there's a link, selecting charging the most serious offenses. It's very, very detailed. I highly recommend that you rely on this DOJ manual. It really, really helps you understand where the government is coming from. And it's not like you're in state court and when we're there, we're seeing the prosecutor every single day in the morning in the courtroom. We know their attitude and we know maybe the training that they receive at their office. we're different dealing with the federal government, so rely on their own manuals. So different kinds of charges that can be brought in the federal system. And just a note as well, you'll often be told by a prosecutor that they have to check with the supervisor. Maybe that's a ploy in state court that you've heard. It certainly happens in South Florida, where really that's just a way of them passing the buck on why it's a bad deal. But in the federal system, that's the truth. And you can read more about that. I won't take too much more time on that. So grand jury indictment, that is the most common way. Anybody who has been accused of a federal crime or arrested for a federal crime is constitutionally entitled to be charged. A felony crime in the federal system is constitutionally entitled to be charged via indictment. They can waive that constitutional right, which we'll talk about. Witnesses, grand juries, we're not going to go too much into it, but this is what a grand jury indictment looks like. Has the charges on top, the names of the defendants, and then it'll have the counts, and then the acts that constitute the counts. And sometimes they're short. I have an example. If I have time, I can show you. Recently that I have is a 71-page indictment. We have no role in the grand jury. So grand jury is dangerous. Grand juries involve 16 to 23 members, and witnesses are compelled to testify, and you are not allowed to have an attorney present if you're compelled to testify. And 12 of those 16 members have to concur. Everything is sealed with the grand jury. It's the most sealed thing. There's no cracking into a grand jury. We have no role in it, and a grand jury really is a rubber stamp. So you'll see here, you may have heard the expression that prosecutors can indict a ham sandwich, or a grand jury is just a rubber stamp. It's terrifyingly accurate. It really is. A couple things. Grand jury, they're secret, closed to the public. We have no opportunity to present evidence, challenge the prosecution's evidence. This is also a standard of probable cause for the grand jury, which if you've practiced in state court, we're familiar with probable cause. It's the same thing. It's one of the lowest standards in criminal law, maybe a little higher than reasonable suspicion. It's defined as requiring only sufficient evidence to lead a reasonable person to believe that a crime has been committed and that the defendant is guilty. Very different than beyond a reasonable doubt. So when the prosecutor goes to a grand jury, they pick and choose what to show them. If we have provided during a proffer session that ultimately didn't result in us working out an arrangement to avoid a grand jury, but evidence that's weak for them, they have no obligation whatsoever to show that to the grand jury. They very much cherry pick the worst of the worst. Okay, just going back to a concept that's important for that before, when we were talking about proffers, I failed to mention something that is known as a reverse proffer. A reverse proffer is absolute huge goal of an investigation stage of the case. That's when you and your client go in and the government lays their cards out on the table to you, and your client doesn't have to say anything yet. And if you can negotiate for one of those, that's great. The prosecutor describes the evidence, and in some cases, pretty much what that is they'll be showing you the worst bits of evidence that they'd be showing to a grand jury. Reverse proffers often take place when their prosecution wants to just convince someone to plead guilty, more often when they want to convince them to cooperate. Sometimes those go hand in hand. I always do whatever I can. You can reach out to me. You'll have our contact information. I have a lot of tips for how to persuade a prosecutor to give you a reverse proffer. But reverse proffers are super important. The reason I bring that up is because the most we'll know about a grand jury is if we can get a reverse proffer where the government shows us what they have, because that's going to be what they're going to show to the grand jury. So that helps us really determine and manage expectations and set our goals as to whether or not we're going to be waiving indictment. I can see in the reverse proffer, say to my client, this stuff does not look good and we've spoken a lot and this seems pretty overwhelming. We should try and cooperate. So all these things kind of work hand in hand. So indictment, sometimes we talked about this, sometimes we decide to waive indictment. That can be usually if our client is cooperating, then there's no need for them to go to a grand jury. Sometimes, depending on the case, the prosecutor will, you can agree to an information, which we'll talk about as well as one of the three types of charges or initiating a case, so to speak. You can waive your right to indictment. Sometimes that's a good idea because you can say to the prosecutor, listen, we can agree that my client will proffer, we're going to be going forward. We're not ready to accept a plea, but if you allow him to proffer and provide information that you can at least evaluate and don't require the client to plea first, because sometimes they will make your client enter into a tentative plea before they allow your client to proffer or do a reverse proffer. You can negotiate and say, all right, we'll agree to an information on one count of wire fraud or one count of child pornography, as opposed to going to a grand jury, and then grand jury could come back with 50 counts. And that's a problem. But usually if there's no proffer, no breakdown, no good line of communication with the prosecutor, then it's hard to convince them to do that. But it is something that can be accomplished. And again, anybody who's watching is welcome to reach out to me, and I can talk about some of the tips on how I do that. There are indictments can't be amended once they're filed, but there can be what's called superseding indictments, second, third, fourth indictments, often adding co-defendants or new charges, and then it replaces the original one. So that's known as a superseding indictment. But there are motions that can be filed to challenge the indictments. So we also have information is the other main part. Indictment is the primary method for certain crimes and certain conditions. We can maybe negotiate a criminal information. Criminal complaint also formally begins a case, but a complaint is really the equivalent of a probable cause affidavit. It's what was necessary in order to make the arrest, but not what was necessary. It's not a charge in and of itself, but it does give probable cause to arrest pending a charging decision. Sometimes, often, I wouldn't say as often, but a lot of times your client will come to you and they've already been indicted. And then at that point, a lot of this becomes superfluous. Information is a formal charging document, describes the criminal charges against a person and the factual basis, does not require a grand jury. Information is presented to a judicial officer, the prosecutor writes it up, and just the magistrate makes a determination if there is probable cause and then can sign the information. Complaint is like a very prolonged probable cause affidavit. It allows for an arrest warrant or an arrest to be made if there's exigent circumstances. They all serve the same function in that they all start a criminal case and inform the client of the charges against them. And they also ensure that a prosecutor has sufficient evidence to establish probable cause that a crime has been committed. So a little bit more about informations and complaint. Again, happens most frequently when the defendant and the prosecutor have reached an agreement as to a plea, to a particular tentative agreement, or agreed to waive indictment, and where the final plea is to an offense different than originally charged. Informations are also used. There's a lot of litigation going on right now about whether or not this is ethical or is appropriate or legal. But an information could be used to avoid violating the statute of limitations. A lot of debate going on right now, at least I know in the Southern District of Florida, because of the pandemic, there was no grand juries for almost 2 years, and prosecutors were getting really close to their 3 or 5 year statute of limitations. So they were just going ahead and filing informations to at least toll the charges. As defense attorneys, we're fighting this hard because we're saying our client had a right to an indictment. So what a couple of judges in the Southern District of Florida have ruled is that it's okay as long as the assistant United States attorney or the United States attorney dismisses the information and files an indictment. Then our client's rights to an indictment were not violated because they got it anyways. And there is the law, I don't believe, is really clear on whether that's an acceptable form of practice. Complaints are used when arrests need to happen quickly, more like how a state court probable cause affidavit. They don't have time to go to a grand jury, so they do a criminal complaint that's drafted by the agent, whereas the information is drafted by the prosecutor. The prosecutor signs off, they still review it, and if the complaint is sufficient, then they'll issue an arrest warrant. Once an arrest is made on a criminal complaint, federal law requires that the defendant must be charged by an indictment or by criminal information if there's an agreement. Misdemeanor cases, you do not, federal misdemeanors are rare, but you don't have a right to be charged by indictment, or the defendant can waive indictment, and that is within 30 days. So this here is a criminal complaint, basically the federal version of a arrest report or a probable cause affidavit that you might be familiar with. And this is a recent case of mine that's public record. Usually starts with the affiant's background and why they have an expertise, which is required for them to be able to show expertise in the area that they're seeking a complaint on. Then it'll go into probable cause, just like it would in a state case, describe the nature of their investigation to date, and ask for a complaint to be signed so that an arrest can be made, to at least maybe if they have fear of a flight risk, or if they've already established enough probable cause to arrest the individual and they don't need to continue their investigation any further at that point. I'm going to show you now a copy of an indictment. So this is an indictment. This is a case out of the Eastern District of Michigan, out of Detroit. You can see that there's several co-defendants here that are listed. Zoom in. Has the violations. These are the co-defendants, the grand jury charges, general allegations, free band gang. And I'm just going to kind of scroll through. You can see how extensive these are going to be. In some certain cases, it's a lot of work to get a grand jury indictment. Conspiracy to commit wire fraud. They'll talk about the object of the conspiracy, the manner and means of the conspiracy, and just overt acts, any conspiracy And the law on conspiracy requires at least one of the co-defendants have taken some step towards the goal of the conspiracy, achieving the criminal activity. Everyone else just has to know about it. Conspiracy is a whole other topic that you have to be familiar with in federal criminal defense, because it's very common and it's very hard to deal with. So yeah, this is just going to scroll through quickly. You can see how encompassing an indictment can be, and how much investigation can be done in an indictment. And it's just 71 pages more of this. So it's a process, and you have to review it very thoroughly. So general practice tips with charging, negotiating charges with prosecutor prior to the decision. We talked about that. Super important. Just makes you look amazing, and it's all about the client. It's not about how we look, but by doing something amazing for our client, we are also just looking great and building that trust. Talk to the prosecutor, have that open line of communication about arranging for a voluntary surrender if they're going to be charged. Find out when the grand jury is, find out when they intend to file the information. Most prosecutors are maybe, at least in the district I've practiced in, and prosecutors seem to be very receptive to allowing your client, with counsel present. I will go with my client to the courthouse on the day of his first appearance after the charge, and present him voluntarily, so he doesn't have to be put in handcuffs and go through that traumatizing experience. Because, of course, one of our goals is just not to let our clients get traumatized by the system any more than they already have.